Hey, good afternoon. My name's Laura Bryant with Castle Group. I'm the Southwest Florida Business Development Manager. Thank you so much for joining us today. If you're not familiar with Castle Group, we are a full-service property management company. We specialize in luxury high-rise and condominiums and full-time on-site management. I'd like to thank Nikki Osmer for joining us from Appleton Reeves. Thank you so much, Nikki, for having us join you really with your educational course. I'm excited to hear what you have to say because I get this question all the time. How do we manage the Airbnbs and the VRBOs that are going on in our community? How do we really regulate that and keep track on things? So I'm excited about today's class and I look forward to hearing what you have to say. And if you will, give us a little bit of information about your firm and yourself.
Sure. Again, my name's Nikki Osmer. I work with Appleton Reeves. We are a full-service community association law firm. We handle everything from turnover to termination of an association. We have been in the practice for a combined level of experience about 50 years. And we have several attorneys that have over 20 years experience each. So I'm very excited to be here. Thank you for inviting me. This is a hot topic that everybody seems to be wanting to discuss. And I will give you guys some tips on how to combat this problem, and hopefully that you'll take away some good ideas that you can take back to your association boards. Okay, so let's get started. The Airbnb industry is a multi-billion-dollar industry. It's not something that's been just come up. It's been in the business now for over 10 years, and it's throughout 200 countries. Other similar models besides the Airbnb website is HomeAway, Tripping.com, HomeToGo.com, and Bedly.com. So there could be any type of websites or services that are provided out there. And the main issue is, how is the relationship set up between the homeowner and the platform? So some restrictions on how you can combat some of these Airbnb issues, because let's face it, these are transients, and it's like having a hotel in your community. So some of the things that condo associations and HOAs can do as far as limiting the amount of traffic coming in through Airbnb is to make sure that you have these restrictions in place in your governing documents. You can have the frequency of how many times people can rent in their community, how long the lease term must be, that there is to be no commercial use of a property, no nuisance. And you can also implement other restrictions either in your rules and regulations or your declarations, depending on what language is already in there. So there's two levels of enforcement in the state of Florida. We have the Florida state level, and we also have the city and county level. And as you will see, there have been a lot of laws that have been enacted over the past few years regarding the Airbnbs, and there's still some more that may be coming up as well. Just for reference, under Florida state government, vacation rentals are a transient public lodging established, defined by Florida Statute 509.242, and it indicates that any unit or group of units in a condominium or co-op, or any individually or collectively owned single-family, two-family, or three-family or four-family home or dwelling unit is also considered a transient lodging. And transient basically is temporary lodging. You go in for a couple of days, you come out, or you can even go in less than 6 months. So the key is, what is the duration of the actual stay, and is it considered transient at that point? So the Department of Professional Regulation, also under the state level, is responsible for these type of rentals. And the DBPR regulates them in terms of licensing. One of the big issues that a lot of board members and managers don't realize that Airbnb is all about taxes. And the local governments and the state governments will implement licensing requirements so that they have a handle on how many licenses are being issued, and also to ensure that they are paying their taxes and licensing fees. So local governments retain the authority to inspect public lodging establishments for compliance as well. They look to see whether or not you're complying with the Florida Building Code or the Florida Fire Prevention Code. So they will come out and do an inspection of the actual property to ensure that you're in compliance with all these local regulations.
So I've got a question. So to clarify with that, so if someone's renting out their condo, you're saying that the local government, going back, oops, there you go. Your local government could come in and inspect to ensure that the owner of that unit is complying by those rules?
That is correct.
Okay.
Some of the big counties out there that have a lot of B&B regulations are Miami Beach, Collier County, Walton, Kissimmee, Disney, Orlando, and Flagler County. All vacation rentals on which payment is made to rent, lease, let, or use for a period of 6 months or less are subject to the county's tourist development tax and collections under Chapter 102. This is also, we also look and see whether or not any of our local communities, such as Manatee County, Hillsborough, and Pinellas County, have these type of regulations. Right now, Hillsborough County does not have any official short-term rental laws that are set in stone. However, there are rental certificates that are required for residential properties in the city of Tampa. So if you do have a homeowner that has an Airbnb, you want to ensure that you check with the DVPR and either your county or local city or county ordinances to see whether or not they are in compliance with the lease licensing requirements, the taxes, and also if they're in compliance with the local city or county ordinances. So the certificate that I had mentioned earlier, the purpose of that is to implement a process that ensures residential rental units within the city's jurisdiction to comply with minimum housing standards as set forth in the applicable cities of Tampa. So again, a lot of these regulations are for safety purposes. We don't want these individuals to be renting out units that are a hazard to the transients that are actually renting them. And it could also cause problems for neighboring homes as well. In January 2020, the city of Clearwater passed an ordinance for short-term rentals to obtain a Florida Department of Revenue certificate. Again, this is for development taxes and state business and professional regulation, transient public lodging taxes. So I'm not sure if anybody remembers a couple years ago, Miami Beach was a really hot topic for Airbnbs, and they had actually fined one of the owners over $50,000 because they did not have the required licenses and failed to pay the taxes that were due on the rental. So when you're thinking about trying to combat some of these issues, a little research may be required to see whether or not they've complied. Manatee County has a tourist development tax that is owed by every person who rents or leases living quarters and accommodations for a term of less than 6 months. Generally, the host or the owners are responsible for collecting these taxes from their guests and remitting those taxes to the appropriate county.
So question, if you've got a homeowner, let's say it's an HOA, and residents are aware that they're on, Airbnb or a VRBO, right? And they want to, they're abusing the situation, or they've got a nuisance renter in for the week, or they're breaking the association's regulations. So the first step for the manager and or board is to follow up with the DPBR, and do they look for that person's information by their address, or could these be listed under, if their home's under an LLC and you can't find it by the owner's name? How would you recommend the best way is to look them up on the Florida DPPR to see if they have the proper documents?
So there's actually pending legislation right now that will require Airbnb to list a license number for the host who's renting out their unit. And I believe that it would be applicable if it passes to all these type of websites across the board. And that should be up for vote, during the legislative session, which may pass July 1st of this year. In other events, yes, you would look it up. I would actually go onto the website itself and look to see who is the person that's actually renting it out, and then contact the DVPR or do a license search. You can do this online and figure out who is the person that's actually renting it out, if it's under a corporation or if it's an individual owner.
Mm-hmm. Okay, perfect. Yeah, sometimes it's just the first steps. We're aware that there's an Airbnb. Now, how do we track down, and what can we do as a manager?
Right. Okay, so we have this issue now where it's the community association versus various homeowners that are renting out their units or their homes through Airbnb or some other form. And you have to look and see also what the relationship is between the owner and the internet company, because that is very significant on how the money is handled. Again, remember, this is all about money. It's about taxes, it's about license fees, and this is a way for the local authorities and the state authorities to keep a wrap on what's going on with these short-term rentals. One thing I did want to make clear is that the actual act itself of renting out the property through Airbnb is not considered a commercial activity. In this case, the Santa Monica Beach case, the Santa Monica Beach case addresses this issue. And it was a covenant that said that the said land shall be used only for residential purposes, nor shall any building on said land be used for a business. So obviously you're renting out your home and you're charging a fee for it. Sounds like a business, doesn't it? Well, the court had determined that it was not considered a business, and that the actual purpose and the actual use of the home was for residential purposes. You have people living in that unit for a certain period of time, and that's what the unit or the home was intended for. And the first DCA actually analyzed the issue and said whether short-term rentals violate restrictive covenants requiring property to be used only for residential purposes are prohibiting its use for a business purpose. So again, you're looking at the actual use of the property. If they were breeding animals, that would be considered a commercial activity. But if they're simply just residing in the unit or occupying the unit for a specific period of time through whatever website they choose to advertise, that is not considered a commercial activity. So what is a commercial activity? The court reasoned also that a rental, even rentals for profit in and of itself, does not transform a home's use from residential to either business or commercial. And the court distinguished this from other decisions which found improper uses based on the frequency of use and type of use, as well as the difference in covenants. So one thing we are going to cover in this class is how do we prevent this stuff from happening? Mm-hmm. Are there any ways that we can implement any rules and regulations on banning these short-term rentals? So one of the things that community associations can do, surrendering is not an option. So we have to find a way to combat this issue and concentrate on the rentals' negative impacts of these, I don't want to call them businesses, but of these arrangements between the homeowners and the leasees. So if there's too much noise, or if you have a lot of nuisance that's combating it, these are some of the things that should trigger your boards to implement other restrictive covenants. As I mentioned at the beginning of class, we're talking about nuisances, the frequency and duration of the rental. So instead, you can say that no short-term rentals shall be allowed in the community. You can say that anything under 6 months is going to be considered a short-term rental. Or you could say that if they're going to be renting out their unit, that they need to have approval by the board, and that maybe they can only rent twice a year if they're going to do it every 6 months. But those are some of the ideas that we could use in order to combat these issues in the declaration.
And Nikki, do you have your best way to regulate that? So we know that there's those restrictions in place, and I know some associations and some don't may have amenities with access cards or gates, which is a way to help regulate and keep track of who's coming in and out. But if they don't,
Your
have
neighbors.
Yeah, that's what I would always
Neighbors
say.
will complain.
Neighbors will speak.
Neighbors will complain to the association. Either there's too much noise, there's too much traffic, and they can see different cars coming in and out. You can also go onto the Airbnb site itself and look up the address to your community and just see what's in the area, and you'll know who is renting out through those websites. But yes, there's different ways that you can monitor it, and you'll know it because neighbors will be complaining.
Yep, they do. And they're aware of the noise and the traffic going in and out.
Yeah.
I agree. Yep.
And you can have repercussions for violation of these governing documents. If you're a condo association, you don't have as much teeth to fine a homeowner as a homeowners association does. So let's say, for example, that you find out somebody's renting through Airbnb and the homeowners association absolutely does not allow it, either through their documents or rules and regulations implemented by the board of directors. You can fine that homeowner for violating the governing documents. And of course, HOAs, if the fine is more than $1,000, you can lien their property and foreclose on that lien. So very effective tool that can be used by an HOA if they violate these restrictions in the governing documents.
I had a question real quick
go
about going back to some money, so we can go back and look and see if they have a license to make sure they're not delinquent in taxes owed, right? But
correct.
What if it's a cash transit? What if you know that they have an Airbnb, but it's a friend, right? And I guess the owner is well aware that they're well aware that they're doing wrong by renting like an Airbnb, but they're being paid cash by these renters. And so there's no trail, if you will, of a transaction. And then when these, specific renters are coming in and out, they're paying with cash, and some pay with, through Airbnb, but it's not consistent with one or the other. How do you track that, I should say?
So you'd be able to track whether or not they've applied for a license and paid taxes. But again, if you have a disturbance in the community and you want immediate relief, call code violations, call code enforcement, call the police, call the tax collector's office. Those are the governing bodies that they want to know what's going on. They want to see these Airbnbs because it's money for the local entities regulating these short-term rentals. And again, like I said previously, in Miami Beach, it was a big problem because there was no regulations at the time, and the homeowner failed to comply with the licensing and tax requirements and was fined over $50,000.
Yep. Yeah. Well, good. Yeah. They won't do it again.
So another thing that I wanted to bring to your attention, besides the licensing and the taxes, is that if a property is actually being rented out through an Airbnb, it's not considered the homestead of the owner. And there may be grounds for the property appraiser to reevaluate the parcel card. This would have a tremendous impact on the owner from a tax perspective because they would no longer be entitled to their homestead exemptions. So just think in terms of what requirements are needed and how you can look to see whether or not this homeowner or unit owner is complying with the local regulations.
Right.
All right, so some proposed amendments. I have actually drafted several of these specifically to Airbnbs, and the rental restrictions for the association are most commonly found in the leasing section of the declarations. You need to add to that, and you need to define what a lease is, to include short-term rentals and what your community is going to consider as a short-term rental. I would always say that less than 6 months, unless you have a condo association that has a lot of rentals and your board may permit it. But in instances where there is normally a resident living there for an extended period of time, focus on the lease definitions that should be included in the declaration, okay? You should also consider either direct or indirectly, including the payment of utilities or taxes or any other charges that would otherwise be the responsibility of the owner. So who's paying for the water? Who's paying for the electricity? Things of that nature. And then also include in the definition of leasing that any type of arrangements for occupancy, including Airbnb, VRBO, or the other websites that I listed earlier in this class, are prohibited. I mean, list it out. Any short-term rentals advertised on Airbnb are strictly prohibited, or any other similar website. So amendment to the declarations is key, because if you don't have these restrictions contained in your governing documents, it's going to be very difficult for you to enforce these regulations and combat this problem.
Now, I've got a question just from the property management side. So with that kind of change to the documents, would an owner look at that as being you're taking away, let's say you don't have that rule, so people are able to rent out, and so that can they come back and say, well, you need 2/3 vote or majority of the association, whatever your documents say, because you're taking away a right of use that I can have for my home at this time. So what kind of pushback do you get for that? And is it hard to get those documents passed once you have them drafted like that?
You know, it depends on the community, because if you have a community that has a lot of rentals, you're going to get a pushback because they are the ones that want to rent out through these websites. However, if your community is mostly owner occupied, I think that the majority of the owners in the community will vote to have the documents amended to include these sort of restrictions in the governing documents. Because whenever I get a client that's complaining about a short-term rental, the first thing I do is go to their declaration to see what it says, because if you don't have those restrictions in there, you're going to have a heck of a time trying to enforce these regulations.
It is. And sometimes you have associations that they're not against it. They just want to be able to regulate, so they know who's in, who's out of the community, and they have a pulse on who's there, right?
Some of the associations that allow rentals, they just want to have like a registration process where they have the owner's name and address and where they can be located, because you don't know when you have transients coming in if they're going to be damaging the common elements of the community, and then you have to fix whatever was damaged by that short-term renter, and they're long gone.
Yeah.
So,
and you want to be able to take that back to the unit owner who allowed the renters in. Yes. And build them.
That is correct.
Yep.
Okay. So, some of the other tools that are available to associations, I hinted on the fining earlier. And again, that's a very useful tool for homeowners associations. If you have people that are renting out homes in the community or even townhomes. If the governing documents actually do address the short-term rentals, or if they are violating the actual rental provisions of the declarations, send them a pre-suit mediation letter if you're an HOA, or send them a violation letter and threaten arbitration if you're in a condo association. So those are also ways that we can sort of get on the radar of the owner that this is not going to be permitted and that we're actually taking steps to prevent this. And if they completely ignore the pre-suit mediation letter or the violation notice for arbitration, you file suit in court. But again, you want to make sure that you have the proper language in your governing documents, because you're not going to be able to go to court and say, Judge, we want to stop Airbnbs or these short-term rentals, yet we don't have anything in our governing documents that says we have the right to do that. So again, if you take anything out of this class today, you have to make sure that you have the opportunity to review your documents and make sure that the leasing provisions cover these short-term rentals. And if you have a provision in your declaration that allows the board to implement reasonable rules and regulations regarding leasing, then you could also use that in your rules and regs, and it would assist the association who has problems getting the appropriate number of votes necessary. But again, when you are restricting someone's use to their property, you should do it through a declaration amendment.
Now, what about just adopting a policy specifically to this? So you have a policy that with the rule and reg change, right? That we have a Airbnb application process, and you've got to show proof of your license. Here's the things that you need to check off in order for you to be approved as a Airbnb renter within that association. And then they have an application process for each renter. So you can publish that policy, right, without a document change?
That's correct. But again, if you're going to be implementing a resolution or a new policy change, you have to make sure that the board has the power to do that. Okay, so again, your governing documents and the language contained therein is very important. So I have drafted resolutions which creates these pre-check-in or notice requirements that the owners have to give to the association when they're going to be renting these out, just so they can have a trail of who was there and what length of time they were there in the event that something does happen.
Right. Yes, please have your attorney look at your documents.
Yes, that's very important. Another issue, if you have these short-term renters that are a nuisance and there's a lot of noise and traffic and what have you, you can send the tenant a formal demand letter. They may be here for a long weekend and they've already started partying on Friday. So have the attorney send the tenant a demand letter that says, if you don't stop, we're going to call code enforcement, or we're going to contact the law enforcement. But nobody wants to get a demand letter while they're on vacation.
Right. Well, during that Friday night party, it's not a bad idea. You can call the police at that point if they're a nuisance, correct?
Oh, sure you can.
Yeah.
Absolutely.
And have them come out and address it.
Absolutely. If you have a habitual owner that is constantly renting out Airbnbs, then that's when I would suggest taking the steps to verify the license, ensure that they're paying taxes, making sure that they're complying with all the local city and county ordinances, because you want to be able to nip this in the bud where you have a habitual violator of these rules. Okay, so there have been a lot of impacts on the short-term rentals due to COVID-19. And, they started approximately February and March of last year. And the state has moved into allowing short-term rentals, hotels, and other accommodations to be opened. But before they were not allowed. And the short-term rental order included some exemptions regarding guests that were staying in the vacation rentals as of March 28th, and rentals to guests working as part of military, emergency, government, health, or infrastructure response are also exempt, as are travelers engaged in non-vacation commercial activities. So there were some exceptions that were made to these rules during the pandemic, and also rules implemented regarding the cleaning of these units or these homes to the next rental who's coming in. And according to the governor's order, violators will lose their rental license and can be charged with a second-degree misdemeanor, which was updated on June 1st of last year. And as I mentioned also, there is pending legislation that requires the online providers to list the actual license numbers of these individuals so that they can ensure that they're in compliance with these regulations.
That would be helpful.
Do I have any questions?
I have some more questions that we had come in. So is there any way to cap the amount of short-term rentals? Meaning, if
that's
you feel
going to
like
be very hard to enforce.
Okay.
But, yes, that would be really difficult to enforce. I wouldn't recommend that. If you're going to do any type of restrictions in the rental department, then make something that's either outright banning it, or that there's notice requirements, or that it can only be for a certain period of time, or for the number of times per year that it can be done. But if you do a cap, it's going to be really difficult to try and enforce that, because some property managers know if you have a leasing cap on just regular rentals, that in and of itself is difficult to monitor as well.
It can be, yeah, because if somebody's going to rent their unit out and not follow the application process, the only eyes and ears you have are the neighbors, like you said, right? Where they say, I know that, this person wasn't here 30 days ago, and there's a different person every month or whatever. And then that's why you have your neighbors to help you identify these folks if you can't track them down. Everybody knows how to work around, right? They try to figure out a way.
Okay. I'm getting a couple questions on.
Yeah. Okay. Good. We
online.
got. Let's see here. Our condominium has guest units that we allow residents to rent for a maximum duration of a week at a time. Are we at risk with these guest units of being seen as an Airbnb?
Short-term rentals, again, you have to define it and what it's going to be. And that could be different for each association. So in answering Marcia's question, it depends how the unit is being advertised. I don't want you to come out of this class thinking that Airbnb is a term of art when it refers to rentals, because it's not. That is just the platform that it's advertised on. So again, looking at your governing documents and seeing if you have a definition for short-term rentals would be the first place I would look. And if I could get a clarification as far as this question is concerned.
Well, I know that a lot of our towers have guest units, suites. So there's usually two, and they're similar to a hotel setup. So if someone has, family coming in town and they would like to rent out the guest suite, they can rent out the guest suite for their sons or daughters or family members. And Marcia says, exactly. Yeah. So that's what they're used for. It's for resident use only, for family or friends that are visiting, and they can rent them out. And usually it's, $100 a night. It's a fair amount, and that's still reported on their financials as income to the association. Okay. So it is monitored. It should be, in our managed towers, it is monitored what that income is. So would that situation be considered? I mean, that's not an Airbnb. That's a resident. That's an amenity for the residents.
That's correct. And I'm sure the governing documents, and correct me if I'm wrong, Marcia, that your governing documents indicate that these units or these suites can be rented out to family guests and members for a certain price, whatever that may be. So I wouldn't consider that an Airbnb because it's actually part of your arrangement, and the governing documents call for it.
Yeah.
So we're talking more about associations that are not set up for this type of rental, and it's disrupting the community. It's not like it's permitted, unlike your community.
Gotcha. So she followed that up with, she said, our house rules do specify the price. I'm wondering if we should add that they can't be rented for commercial purposes. So just adding in some additional verbiage that they're not allowed to be used for that.
Yes. And again, remember, your commercial purposes would be different as far as the leasing is concerned, depending on what they're actually doing in the unit. So remember that just renting out your property isn't considered a commercial activity. But I do think that you should put in your rules that these are not considered Airbnbs and do not require licenses because they're being rented out to family and friends.
Right. And commercial would really be if you're it'd be hard to do that in a tower that has guest units, because that all goes typically through the manager in the management office. They're renting that, through the business of the association, if you will. And it's not like they could rent it and then, well, I guess they could rent it and then up the charge and have somebody else come in, but that would be a lot to go around.
Yeah.
Yeah.
So we have another question from Donald.
Yep. Do you think the Airbnb bill will make it through the Florida legislature and be signed by the governor this year?
Yes, I do, because it's just a reasonable. It's not burdensome, and it will track all of the Airbnbs through the state or county, whichever has the rules and regulations in your community. So I think it's a good thing, and I think it is going to pass, hopefully. But you never know. We all thought emotional support animals was going to pass 2 years ago, and it didn't.
There's lots of workarounds. Yep.
Yeah, so we never know.
Yep. So another question that had come in previously, other than changing your documents, what can be done to stop short-term vacation rentals in a residential condo? You're not going to be able to, correct?
Well, unless if your governing documents call for the restrictions, okay, then you have several avenues that you can follow. Pre-suit mediation letters, you can find the homeowner, you can file a lawsuit and get an injunction against them. So it depends on what your declaration says and what you will be able to accomplish through those regulations.
Right. I'm reading, let's see. Somebody just asking if you can, so I guess this is a pre-submitted question, that can the owner of the unit be present during how some people will sign up their Airbnb and there's a one bedroom or something, but it's really a 2-bedroom condo. So they rent out one bedroom.
Yeah.
I've seen it on Airbnb. I don't know that I would want to stay in a house with a stranger, but that's just me. It sounds like some people do.
Yeah.
Is there regulation on that? I mean, I know that you can do that on Airbnb. I don't know how you would regulate that if the owner says, well, I'm here.
Again, remember what we're trying to prevent is the nuisance to the other neighbors in the community. So if you have someone that's renting out a room and the homeowner is actually living with the unit owner, the tenant is living with the unit owner, as long as there isn't an issue, that it would be regulated as a short-term rental. And as far as the licensing is concerned, if they're advertising on Airbnb for short-term rentals, then yes.
Okay. So I think the biggest thing is just coming away from this is identifying what, you're wanting out of this resolution, right? Is it who's
Mhm.
coming in and out of the unit? Is it because we have a problem with renters in general, meaning they're nuisance, right? Kind of
Yes.
looking at your
Yeah.
association as to what are we trying to regulate, and then what are we legally um,
Able to do.
able to follow through with, and how are we going to control this, right? Just like
Correct.
you said.
Correct.
So coming up with that game plan, but I think, you saying checking with the DPBR and looking for licenses and looking on the websites, I think that's a great way to start. You pull up the
Mhm.
websites of these different entities, and for different companies, and you can look and see, how many are within in our association that are online and live, and then go to the DPPR and look for licensures and see what's going on, and if they're following the current laws that are in place.
Correct.
All right. So one of the last questions, will I be able to rent my house on Airbnb or as a vacation home, or do you think this is going to all go away at some point?
Oh, I think it's here to stay and it's not going away.
Yeah. Yeah, no, I would agree. I think, when I've been on site as a manager, and, some people feel like if they ever get transferred and they feel like that right to rent is taken away, they have a job transfer and they have to leave and they can't sell, they feel financially tied and that a right has been taken away, they can't rent. But the Airbnb is it's a faster turnover, right? It's a week, it's a
Right.
month,
And
that's the
again,
problem.
remember that if you're restricting somebody's use of their property, you're going to have to get a membership vote to change anything, unless you have language in your declaration that allows the board to implement reasonable rules regarding rentals. But I always err on the side of caution and get a declaration amendment voted on by the members, because that is going to hold up a whole lot more in court than board rules and regulations, because they're not voted on by the members.
Right. Yep. Exactly. Very good point. Thank you. I do have a question. Do you have, are you okay if we email a copy of this presentation in a PDF format?
Oh, sure.
Some people have asked for
Absolutely.
that. Okay. And
Absolutely.
I'll be sending out your contact information. So everybody that's joined us
Okay.
today, I'll send a follow-up email to everybody with your contact information and ours if they have any further questions, and a copy of today's presentation, because this was very informative.
Thank
And we'll
you.
see what July brings, right?
Yes.
We'll have to meet again after July.
Yeah. We'll see what happens.
I know. Well, thank you, Nikki. Any final words?
No, if you have any specific questions about your community, please feel free to email me. I'd be happy to respond and maybe give you some tips on how you can combat the problems faced in your community. Oh, I think somebody just gave us another question. Hang on.
They did. They said, don't hang up yet.
Don't
Ed
hang up.
Robert. Yep. Our declaration says that we will abide by the county rules, which require 30-day rentals. The board is not enforcing.
Oh, that's another issue. If the board is not enforcing the rules and regs or the declaration, and then all of a sudden they have a unit that's a problem, you're selectively enforcing. You have to enforce the rules across the board, or else you're going to get an owner who's probably going to file suit against the association for selective enforcement. But as far as the 30-day requirement rental, that again is local ordinances, but there is no prevention of actually renting the unit or the home to the end user.
We got a couple more questions that just came in. But yes, true. You cannot do selective enforcement. You're going to get yourself in trouble. So here we go. Another question. The Airbnb legislation exempts 718, 719, and 720 associations. We are not. What will be our status?
What are you? If you're not any of those three.
617, possibly.
Oh, just the regular corporate statute?
Yeah. Yep. I think that may be, yeah. Is it, if they're just 617, yeah.
At 617, okay, that's just a corporate statute. It's how the operations of the organization are run. And those are generalized rules of corporate or corporation entities. So I don't believe it's going to be applicable to that. It's exempt for the 3 statutes that were cited.
Okay. And another last question here so far, did you say put rules against short-term rentals and the rules and regulations?
Again, if your declaration provides that the board can implement reasonable rules and regulations regarding leasing, then yes, you can. But again, I err on the side of caution because you are restricting someone from using their property. And you should have a membership vote to amend the declaration if your governing documents do not address short-term rentals at all. Mm-hmm. So let me explain as far as that is concerned, because if you have something in there that says we don't allow rentals at all, only maybe under reasonable accommodation or something, and it says that the board can implement rules and regulations, again, your governing documents do not permit renting at all, but if they want to make an exception for that accommodation, then they can put in rules and regulations regarding those accommodations. So you want to make sure that you have the short-term rental restriction specifically,
yep,
and then implement rules and regulations to expand on that. So right. Your rules are always expanding on what's in the deck. So if you don't have anything in the deck regarding
you can't do it.
Short-term rentals, you can't do it. Exactly. You're going to find yourself.
Don't do it.
You have no power, and you have nothing to fall back on, obligating these owners to stop renting their houses out on a short-term basis.
Right. So if that owner takes you to court, it's not going to be, and the judge is not going to look on the association side for that if you don't have that verbiage in your documents. One other question: can an Airbnb be longer than 90 days?
Again, it depends on what your association is going to use as its definition of a short-term rental.
Okay.
It also depends on what county you're in, because each county has a different time frame as to what they consider to be transient housing. So it depends on what county your association is located in.
That's really important then. Yep.
Yes.
Okay.
Because
so
check
your documents. All right. Check your documents and check your county.
Absolutely.
Okay. Great points. Well, wonderful. Let's see. Anybody else have any further questions? Going once, going twice, and Nikki gets to go have lunch. All right. Thank you so much. I enjoyed this.
Thank you, Laura.
I enjoyed it. I learned some more myself. So thank you guys again. We got another question or maybe statement. All right, we got one more. Can a unit owner request to see the rental applications? Applications for other units or their specific unit? I would have to ask.
Yeah, can you clarify on that, Edna?
And
other units, no. And here's why, Edna. There could be confidential information in the application. You may have a social security number. You could have a driver's license, and none of that information is considered official records of the association and should not be disclosed. So no, if you're asking for other rentals or other applications, I wouldn't consider that an official record, and I wouldn't disclose it.
Yep, I would agree. Yes. All right. Well, we are good. Thank you so much, Nikki.
All right. Everybody have a wonderful day. And again, if you have any specific questions that you'd like to ask me that I could assist you with, my email is on the screen. Please feel free to email me.
Wonderful. And I will send your information out as well.
Okay. Thank you so much. Oh,
hey.
I think we have another question.
Edna says thank you.
Oh, you're welcome, Edna.
All right, wonderful. Thank you so much. And I will be emailing out the PowerPoint and your contact information. And I appreciate it again. And I look forward to seeing you again.
Thank you.
Thanks, Nikki. Take care.